each cause number, did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you to 10 years in prison and each cause number and up to $10,000 fine? Did you understand? Counsel, court is calling 2025 CR 014065, 2025 CR 014136, State versus Dominic Smith. Can I have parties announce?
Remaining for the state of Texas.
Roger Bettis for Dominic Smith, Your Honor.
And are you Mr. Smith?
Yes.
All right, counsel, have you received all discovery in each of these cause numbers and did you review it with your client?
Yes, Your Honor.
And each cause number, the court will find that the state is in compliance with discovery. Mr. Smith, in each cause number, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, in each cause number, do you waive the reading of the indictment?
We do, Your Honor.
State, in the cause number ending in 6-5, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
And in the cause number ending in 3-6, are you proceeding on the indictment as presented?
We are not, Your Honor. We are proceeding on count 3, and on that one, we'll waive counts 1 and 2.
No objections, Your Honor.
And Mr. Smith, in each cause number, did you review the application for deferred or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
In each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? And cause number 2025 CR 014065, you're charged with violation bond or protective order 2 times or more within 12 months. And in cause number 2025 CR 014136, you're charged with stalking. These are third-degree felonies. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. That you intend to give up those rights and enter into pleas in each of these cause numbers. In each cause number, did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you to 10 years in prison in each cause number and up to a $10,000 fine? Did you understand? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Smith, in either of these cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, and re-entry. Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes.
And cause number ending in 6-5, according to the plea, punishment is to be assessed at 6 years in the prison. There's a $1,500 fine. State is opposed to your applications. This will run concurrent with the case number ending in
Now that you said, I think I need to fix that.
all right. Any objection to the court just correcting that?
Yes.
All right,
Objections.
no problem. This is the run concurrent with 2025 CR 014136 and 2025 CC 014639. The state is taking in consideration 2025 AL 001293 and 2025 AL 002994. And there's to be restitution, if any. And there's to and the cause number ending in 36. The state is proceeding on count 3. Punishment is to be assessed at 6 years in the prison. There's a $1,500 fine. State is opposed to your applications. This will run concurrent with 2025 CR 014065 and 2025 CC 014639. They're taking in consideration 2025 AL 001293, 2025 AL 002994, restitution, if any, and the same no contact orders. Did you understand that to be your plea in each of these cause numbers? Defense is at the plea?
It is, Your Honor.
State is at the plea.
Your Honor.
Did you review the waiver of appeal paragraph with your attorney in each of these cause numbers? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
There have not been, no.
Then in cause number 2025 CR 014065, how do you plead? Guilty, not guilty, or no contest?
No contest.
To count 3 in cause number 2025 CR 014136, how do you plead? Guilty, not guilty, or no contest?
No.
State any evidence.
Mr. Chairman, with regard to both cases, state will offer into evidence if exhibit 1 of all fact.
No objections, Your Honor.
All right, and state, have you spoken with the complainants? All right, thank you. State, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. In each cause number, the review and states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt in each cause number as you apply for deferred adjudication. All right. Counsel, if he wants a full PSI, it's going to be about 8 to 12 weeks. If he would like to come back sooner, if you waive PSI, what will end up happening is I'll give you a chance to have whatever witnesses or whoever you want brought in to testify or whatever evidence you want to present to the court. But otherwise, it'll be 8 to 12 weeks for a PSI and TAP evaluation.
Mr. Smith is very motivated to get out, so the sooner the better. And yes, will there be any, you'll just have some confirmation of his record or anything from the PSI?
The state will probably most likely give me any type of criminal history. But what I can tell you all from reading the stipulated evidence, do you think he needs a MIC evaluation at least?
He's a veteran, spent 4 years in the military.
Mhm.
And on a particular date, I don't have the date in front of me, Your Honor, he had a motorcycle accident, which his case is pending.
Mhm.
So there was a TBI involved. So I have a volume 1 of his medical that I was going to try to succinctly place before Your Honor.
Okay.
And the better news is he has grandparents who are here present. They've been very active through the case this entire time. very supportive. If we were to be granted probation, he would reside there immediately. The same day or the following day, he's going to be in with the doctor to get the appropriate medication to assist his situation. And will have the resources, we think, based on the accident, resources that we think we're going to get as a result of the traumatic brain injury accident. And so none of these things are going to occur in the future. He's going to be a stable resident. He's going to receive the right medication. He's going to have just a new outlook. He's been, very remorseful about this whole entire situation and what he did. And, he realizes the situation he got himself in. He spent almost a year in custody and he's just very motivated to get out.
Okay, so I mean, that's information you may want to let the state know. So do you want a MIC evaluation? If there's a MIC evaluation done, how long would that still be? 8 to 12 weeks?
Judge, I could probably get it done in 6 weeks.
Give me one quick second.
Sure.
Regarding a MIC evaluation, we've already, in the volumes of information I have, there's already been an evaluation. That'll be some of the testimony that we'll provide to the court. So we could have just a shorter time frame, maybe a few weeks before we come back.
How long would you request
In terms of
time for us to come back?
3 weeks or so would be fine, and then I'll get a packet ready for the court and the DA for that day.
All right.
And we probably need about 15 minutes in terms of court time with the grandparents to testify.
Is veterans treatment for an option?
We can do yes, I think we should probably see about Veterans Treatment Court.
I just text to see if someone can know.
Okay.
Okay. All right, Ms. Ferguson, I need a date. Well, you know what? Let's not do a date yet. Let's confer. You confer with Veterans Treatment Court.
Okay.
Just have a seat and then we'll come back and I'll give you a date. But I'll note for the record that you're waiving PSI and TAP evaluation.
Thank you.
All right, so just have a seat and they'll be up here.